Any mention?
Lord, I beg to make a mention of item 7, my lord. If it is listed up, kindly listed after 2 weeks.
Yes.
I'm trying for 2 weeks time. my lord.
No objection, Lordship.
7. On prayer made on behalf of the petitioner, not objected to by the learned counsel with the respondents. List after 2 weeks. Yes.
My lord, on behalf of the state, my lord, I'm making a mention of item 9. It's kindly taken up after 2 weeks.
Why?
After 2 weeks.
Why? Why?
My lord, some personal difficulty today. My lord.
Yes. Just say on prayer made on behalf of the state respondents, not objected to by the learned counsel appearing with the petitioner. List after 2 weeks. Yes.
Obliged.
My lord, I also beg to mention item number 11. Here, my lord has directed to the state to file an affidavit. They have filed an affidavit. We just received. We need some time to go through, my lord.
What for that affidavit?
Affidavit, my lord, it's for utilization of the SPV funds, my lord. That Nongtrai village, my lord. So they have submitted. We got. We need some time to go through and prepare, my lord. So a week's time, my lord.
That is affidavit is what affidavit? Is it additional affidavit or what?
Additional affidavit. Lordship.
Additional affidavit.
Bring
Yes,
on
my lord.
record the
Okay, it is submitted by the learned state council that an additional affidavit. This matter has already been filed. Mr. Yuvin, learned council appearing for the petitioner, prays for some time through the affidavit. Very Lord, list after?
After a week, my lord.
After 1. Yeah.
Obliged.
Please.
Your Lordship, mention item number 10.
Item 10. Yes.
I'm really this matter may be taken up after 3 weeks, Your Lordship.
Yes.
I've informed my friends.
Who is?
My lord, I'm for the corporation here, Lord.
No objection.
No objection, my lord.
Yes, on prayer made on behalf of the petitioner, not objected to the learned council appearing of the respondents, list after 3 weeks. Yes.
Fully obliged.
Lordship,
Yes.
my lord, I have received a affidavit. As per your direction, they have filed an affidavit. I need some instruction on this. At least 3 weeks time may be granted. My
Which
lord.
item?
As per your lordship, item 8, my lord.
Item 8. Yes.
Item 8. As per your lordship direction, now they have
Who is
filed
applying
an
for the
affidavit.
who is applying? Dr. Majika.
Dr. Majika is there.
Yes. And then affidavit has been filed by whom?
Lordship, we have filed an
By
You have filed an affidavit. Okay.
I pray, my lord, 3 weeks time.
Is an
I will take
additional
some
affidavit?
Lordship. Lordship.
Yes. It is submitted by the learned council for the learned council appearing for the respondent that an additional affidavit in terms of the order passed by this court has been filed. Stop. Mr. Chanda, learned council appearing for the petitioner, prays for grant of some time to go through the same. Mr. Prayer alert, list after? Yes. How long, Mr. Chanda?
3 weeks, my lord. 3 weeks, my lord.
List after 3 weeks. 3 weeks, all right? It's all right.
Obliged.
Okay, yes.
All right.
Yes, 3 weeks.
Much obliged.
Obliged.
My Lord, I'm appearing on behalf of the conducting council for item number 20. The conducting council is unable to appear before this honorable court as he is sick. So I would pray that the matter may be taken up after a week's time.
See, what is the purpose of taking time on weekly basis? Taking long time. There's no, you see, it is nothing. We unless make this order sheet voluminous. Every week you have to pass for order adjournment, and you ask time as if that you will be going to do it on next week. It never happens. This is a case where every time 1 week time is taken. Just see the thing. You want longer time, this court will be granting you. What is the use of asking time in piecemeal?
My Lord.
This every time this is a case where 1 week time. Is Mr. So-and-so, learned counsel, appearing? Learned counsel submits that. Mr. Who is the counsel appearing for the appellant?
L. Naksaka.
Mr. L. Nagaka. Just see from the cause list. Learned counsel appearing for the appellant is indisposed and prays for grant of some time. The learned G appearing for the state respondent has no objection. Prayer allowed, list after 2 weeks. Yes.
Highly obliged, my lord.
May I please, Your Lordship? I beg to mention item number 22.
Yes.
I pray for 3 weeks' time, my Lord, for the hearing.
No objections, my lord.
22. One request made on behalf of the appellant, list after 3 weeks. Yes.
Team brief.
Please, Your Lordship. Your Lordship, beg to mention item number 13, Your Lordship. If Your Lordship can have this matter after 2 weeks, Your Lordship.
Who's the other side?
My lord, I'm for the corporation here again.
State is also a party?
My lord.
No objection.
Mr. Philemon is sanctioned it, my lord. No objection.
Okay, just say no. One request made on behalf of the petitioner. One not objected to the learned counsel's appearing for the respondents. List after 2 weeks.
2 weeks.
Yes.
May I please, Your Lordship? Lordship, I beg to mention item number 6, my lord.
Yes.
I'm praying if this matter will be taken up after 2 weeks, my lord.
Why? This is 2014 matter.
Because today, my lord, Mr. Paul is not here, my lord.
This is from 2014 it is fine.
My lord, it's a whole matter, my lord.
No objection, Lordship.
So order say on the request of the petitioner not objected to by the learned counsel for the respondents. List after 2 weeks. Yes. 2014 matter. Actually, you should do. See, this is a matter. What you will gain by keeping it alive?
This
tell
pertains
us.
to, my lord, subsidy under the...
That is what. So after 11 years, what subsidy you will get? What claim will remain?
My lord.
Your prayer of adjournment make your case bad. You give an impression to the court that you do not have anything to argue in this case.
My lord.
Yes. All right. 2 weeks. Okay.
My lord, item number 15 and 16, my lord.
Yes.
This person pertains to the squashing of POXO proceedings, my lord. I'm praying if this matter can be taken up after 2 weeks, my lord. So the matter is pending in the review.
Please, Your Lordship, item number 18 also, sir. 1-8.
So all 3 matters you just
Yes.
done. When do you want it?
After 2 weeks.
2 weeks.
Okay, just say all
Right.
3 matters. Okay. On prayer made on behalf of the petitioner. Just 15 and 16 so on prayer made by the learned legal aid counsel appearing for the petitioner. This is matter after 2 weeks. And the other one just on prayer made on behalf by Mr. S. Marpan, learned counsel appearing for the petitioner. In this item 18. Okay. Yes. This after 2 weeks. Yes. Yes.
Please, Your Lordship. Lordship, I beg to make a mention of item 14.
Yes.
Lordship,
You are appearing for?
I'm from respondent for 2A, Your Lordship.
Who is petitioner here?
Lordship, I'm seeking for a week's accommodation, Your Lordship. I'm seeking for a week's accommodation, Your Lordship.
Why?
Senior counsel is leading us in this matter, Your Lordship. And
The
he's
record,
having some personal difficulty.
I
Your
don't
Lordship.
know whether the record has also come. There is an order for produce the record, Lordship.
Record from the district council?
Yes. It is not then automatically.
So your prayer, you are making a prayer on behalf of whom? Mr. Day, you are, is there any order for production of record in this case?
I have prayed also on the last occasion to produce the record, my lord. I have yet to receive. Since
So
we are praying,
when you will be able to produce it?
1 week, my lord, I will be able to produce it.
So 1 week will be all right.
And for me, my lord, it is.
No, that is for what is he is asking for 1 week's time. See, what
Yes.
matters is that when you will be able to produce the record.
What is already with me, my lord? Only need to classify, my lord.
Okay. Okay. Just say on prayer made on behalf of by you are
Respondent 428.
this is matter after 1 week. Okay. Yes.
Much lordship.
Lordship, item 12, Your Lordship.
Yes.
Lordship, this matters, similar matter is pending before division bench, Lordship.
Is it?
Lordship.
So why do you have then this matter? If a similar matter is pending before DB, then allow to DB proceed. Let us close this matter.
Lordship.
And we'll give you liberty if, to approach the court if there remains any cause of action.
With the
Yes.
Yes, Lordship. In the DB Lordship, the division bench Lordship, they're questioning the rules and.
This matter is connected with that.
Yes, Lordship.
It will have
This is
some
tender
bearing.
matter, Your Lordship.
It will have some bearing with this.
Lordship.
Yes. Just say learning council appearing for the party submits. Party submit that a connected matter pending before the division bench of this High Court is yet to be disposed of. So in view of the submission, list this matter after 4 weeks.
Lordship, matters coming up again on the 25th, 26th, 27th, Lordship. May I have it after 4 weeks, Lordship?
After 4 weeks. Yes. Yes.
Obliged, Lordship.
May I please, Your Lordship? I beg to mention item number 17, Your Lordship.
Yes.
Pray for 2 weeks' time, Your Lordship.
No interim order here. Is there any interim order?
There is, Your Lordship. There is
So why you are asking for time then?
some difficulty, Your Lordship.
And there is no objection by the state. Even in spite of the fact that there remains interim order.
After instruction,
What instruction? If there is any interim order that is against your interest. Just say on the prayer made and we have decision. List after 2 weeks. Yes.
Highly obliged, Lordship.
Supplementary cost list, item number 1.
Yes.
May it please your lordship. Your lordship, the husband of the petitioner, namely Spolan Shila, was working as an assistant teacher in Nokse LP school, my lord. The husband of the petitioner was serving the school for more than 25 years and he retired in the year of 2015, my lord. Thereafter, my lord, the petitioner's husband was running from pillar to post, my lord, just to get the pensionary benefits, my lord. Thereafter, he expired in the year 2021, on the 25th of July 2021, my lord, he expired. The death certificate is at an extra 6, my lord. Page 33, my lord.
Annexure?
An extra 6, yes,
Page?
my lord. 33.
Yes.
Yes, my lord. He expired on 25th July 2021, my lord, and he retired in the year 2015, my lord. Thereafter, he did not receive anything, and then after he
Before his death also he did not receive pension.
no, my lord. Then after that, his wife, my lord, she went to the office, my lord. Several times he spoke to them and communicated to the respondents, my lord, to release the pensionary benefits. Thereafter, my lord, they have thereafter the petitioner, my lord, who is the wife of the deceased, my lord, she had filed a representation, my lord. My lord, representation is at an extra 6. At an extra 6, my lord. Non-disposal of pensionary gratuity leave and encashment and other terminal benefits of my late husband, Shri Spondan Shila.
Yes. Who is appearing for the other side?
I need to take instruction, Your Lordship.
What instruction? Why this is? Wait. This is not a government school.
This is a government school, my lord.
No.
This is a semi-government school, my lord.
It's a aided school.
It's a,
See, all your annexures.
Yes,
there are
my lord.
constitution of managing committee.
yes, my lord.
So,
It's an aided school, yes.
Where is the provision of pension there?
My lord, but he was entitled, my lord.
How? Under what law? Whether, yes, whether just say, yes, Miss Colony, whether they are this non-government, the idiot school teachers are not entitled to pension. Yes. What kind of case you are coming with? And you also do not even go through the file also. What is there, what is not there. Only this just because these documents are attached there, Constitution of Managing Committee.
But he was an appointed teacher, my lord. He was appointed on 1st March 1984, my lord.
Appointment is a different thing. If you are appointed as in a sanctioned post in an aided school, does it mean that you will get pension? Do you become a government servant?
My lord, but he's receiving salary from the government.
My God. Just do some study and then come back. You take instruction, issue notice, returnable in 3 weeks.
Respondent 1 and 2, Your Lordship.
This is something, at least you should do your homework before filing a case. Mr. Issue notice, returnable changes, Mr. So-and-so landed GAPS for the respondents. Stop. And hence no further notice is called for. Stop. Then paragraph, the landed GSL obtain necessary instruction before the next date. List after 3 weeks. Do some homework and then come back.
Highly obliged, madam.
Probably there are litigation pending for praying for grant of pension, isn't it? So you must have information about that.
Item number 2.
Yes. Another service matter. Yes, what is this?
My lord, this is a case, my lord. The petitioner is a government servant, my lord. He is working as LDA. She is working as LDA in the Deputy Commissioner's office, my lord. Now, my lord, way back in 2019, my lord, the petitioner had applied for leave for 9 days, my lord. That was sanctioned because she had to take her daughter because of the daughter's studies at Delhi, my lord. That was sanctioned, my lord. Subsequently, my lord, the departure of her daughter got deferred, my lord. Thereafter, she again filed.
What deferred? What is?
The date of leaving Shillong, my lord, got deferred. And my lord, subsequently, the petitioner filed another application for my lord, for postponing her leave, to convert her leave.
Change of period of leave.
That was
also
also
granted to her.
That was also,
because there was a change in program.
my lord.
Yes.
And well, that was also approved, my lord. So, my lord, I proceeded for Delhi. I come back, and then thereafter I again rejoined my duty. Then, my lord, I am slapped with a notice saying that I had proceeded without sanctioned leave, my lord.
Okay.
9 days. Thereafter, my lord, I filed my SOCAS. Subsequently, my lord, this filing of the SOCAS, my lord, suddenly, my lord, I was transferred, my lord, from Shillong to Sora, my lord. So, my lord, so this indicates it's a punitive transfer, my lord. That apart, my lord. So, my lord, after receiving of the transfer order, my lord, because of my medical condition, my lord, which is I have enclosed also, I had collapsed in the office, my lord, and I was shifted to hospital. Thereafter, the DHS, Director of Health Service, my lord, certified that my condition was bad and has given a certificate to the effect taking rest and medication for about a month, my lord. The certificate is also enclosed, my lord. Now, thereafter, my lord, I had filed my representation to the authority concerned to, my lord, revoke or to reconsider my transfer, my lord, in view of the fact of my medical condition. My husband, who is a cancer patient, my lord.
This happened in 2019.
2009.
Yes.
Now, thereafter, my lord, because I could not join because I was under medical rest, my lord.
So they did not consider, they did not
consider.
accede to your request.
Exactly, my lord. Now thereafter what happens, my lord? Suddenly,
Then you remained here. No, you joined at Sohra.
no, my lord. Now in between what happened? Well, before joining of Sora, my lord, because I was under medical treatment, my lord, in the meantime I was slapped with a suspension order, my lord, from service.
For?
For, my lord, for not joining the duty there and for unauthorized leave.
Okay.
Now what is that?
In spite of rejection of your representation, you did not go and join there.
But the fact remains, my lord, it is on the record, my lord, that my application and the DHS
No, but then
certificate.
once it is not considered favorably, then it becomes your duty.
That is true, my lord.
Or did you make a challenge to that transfer order subsequently in any judicial forum?
No, my lord. No, my lord. Now, my lord, that is one aspect of the matter. At that point of time, it is not a dispute. It is not disputed, my lord, that I was under bed rest, my lord. Now, I was kept under suspension way back in 2019, my lord, and till date, my lord, I was never given my subsistence allowance also, my lord. That apart, my lord, suddenly, my lord, now there is a provision in the SR and FR rules, my lord, FR and SR, my lord, where, my lord, even if, my lord, for the moment that if it is taken that my leave was unauthorized, my lord, there is a provision even for converting it into extraordinary leave.
But then that is a discretion of the department.
Exactly.
There is a provision.
Exactly.
If they want, they will do it.
Right now,
What matters most is that you justify your absence.
exactly, my lord.
Yes.
Now, that is one aspect of the matter. Now, suddenly, my lord, 5 years, 8 months, my lord, I am without subsistence allowance, my lord. And that apart, after, my lord, suddenly the department wakes up. There was slumbering over my case. They never initiated departmental inquiry, my lord. Whereas, when I was put under suspension, my lord, there is a notice saying that a departmental proceeding will be initiated against you, my lord. And they slept for more than five and a half years, my lord, and suddenly wakes up and sends a notice to me to appear before.
But then if there is admittedly some unauthorized absence on your part,
My lord.
and department contemplates to start a departmental proceeding, what is wrong in it, and which we can stop from doing it?
Exactly.
We are not to judge the situation,
Exactly.
whether your absence was.
Exactly, my lord. Now, my grievances before your lordship is that the department cannot, my lord, delay for such an unexplained delay for such a long time, my lord, because of which, my lord.
Where is the departmental order for departmental? You said that there was no SOCO's notice before this departmental proceeding was.
Way back in 2019, my lord.
Where is the order?
I was never, my lord, I was never issued with the inquiry
See,
report or the charge.
The fact remains that from 2019 you are not going to office. What more is needed?
Because
If
I was.
that is the admitted thing. Probably even holding of departmental proceeding also is not required.
My lord, my lord.
It cannot be. And if you say that you are kept under suspension, suspension doesn't mean that suspension. If you are suspended also, you have a duty to go and report.
My lord, I have been suspended from the office, my lord.
Yes.
And no subsistence allowance also, my lord. And my lord, I have been.
That is one thing they will have to explain. Definitely.
Exactly. So, my lord, suddenly, my lord, after nearly
Where is the
6
order of
years-
suspension?
Here, my lord, at Annexure 17, page 28, my lord.
No, annexure. Page
Annexure,
20?
page 28, Annexure 17, my lord.
Your Lordship, from this suspension order, it's clear that the leave application was not accepted, Your Lordship. And moreover, Your Lordship, whatever notice was sent to her, Your Lordship, she refused to accept. That's why, Your Lordship, a notice had to be published in a newspaper also, Your Lordship.
See paragraph 3. Read it.
Yes.
This is allegation.
Yes.
You have even threatened the process server.
Yes, Your Lordship.
My lord, that is their stand, my lord. But, my lord, before.
See, 2019 order, you are coming now after 6 years.
My lord.
And that too, see, remaining without duty.
My lord, when I have been suspended, my lord,
What is this pen? Page 30? Annexure
page
18?
13,
Annexure 18, page 30.
Direction to the petitioner to appear
Now
before the
they wants to
presiding
hold
officer,
the
Your Lordship.
proceeding, my lord. Can
No,
it
that
be?
is with the ongoing departmental proceeding.
No, my lord.
So where is the order by which departmental proceeding was initiated?
I was never, my lord, given a notice to that effect, my lord.
There is some missing link in your petition.
Exactly, yeah. Because that was never
You
communicated
see,
to
your
me.
things are narratives. It seems like that something has been left out. So we do not know whether it is intentionally or it is because of the things. Where is the order drawing departmental proceeding?
It
See,
has not
this
been
is
imposed, Your Lordship.
See the contents of page 30.
Page 30.
In pursuance of your letter dated 28 May 2025. Where is that letter dated 28 May 2025?
Now, my lord, what had happened here?
Where is that letter? We want to see that letter.
My lord, I can bring that on record.
No, that should have been there also.
No,
When
what-
you do, it has been fixed. Just read it.
Yes.
You are hereby directed to appear before the presenting officer on 9 June 2030 in connection with the ongoing departmental proceeding.
My lord.
That means there is some order. Where is that order?
My lord, if I may clarify, my lord. My lord, what had happened? I was given a notice, similar notice like this, my lord, a week back prior to this, to appear before the departmental committee, my lord. Now, what had happened, my lord?
So where is that letter? And where did you respond to that?
My lord, I can bring
You
on
have
record.
referred to this and all.
I'll bring on record.
And you will just issue notice. You
Your
just take
Lordship,
instruction
I'd
with
just
regard
like
to
to
the
point
subsistence
out
allowance.
that this date of appearance was fixed yesterday, Your Lordship. She did not appear.
It's okay, no problem. We'll just issue notice, nothing
Yes,
else.
Your Lordship.
This is even, there is a missing link. It seems like it's something, this conduct that you see, like you remain absent from duty for such a long period and thereafter you come to the court.
My lord,
See,
my
delay
lord,
defeats security.
it is not that, my lord. The petitioner here, my lord, was, my lord, stopped from joining her duty because of the in view of the suspension order, my lord. It is not that I didn't wanted to.
See, there appears to be a notice issued in the newspaper also,
Exactly, my lord.
saying that you are absent from duty.
My lord.
See, come at page 20
Yes.
on the top left hand side.
Yes, my lord. My lord, I am coming to that, my lord. Now, my lord,
Just
this
let us wait for their things. Since you have come, these things will issue notice. Issue notice. If you say that it's a case of non-payment of subsistence allowance also, that is also quite surprising. For 6 years you are surviving with your subsistence allowance.
My lord, I had been.
Took you 6 years to approach this court for getting subsistence allowance.
My lord, I had
There
been
must
running.
be something which is not here. We do not know.
My lord,
It is not there in the petition.
my lord.
At least let her obtain instruction without. Facts are not very impressive.
Rule itself says, my lord, that I am entitled, my lord.
We'll
It is
see.
not
We'll
that.
look into it, but then after we get easy clue about those missing links, let us see what they.
Can we look at the conduct of the department, my lord? In a
It's
war
okay, it's
footing.
okay. You see, that can be revealed once we get a response from them. Otherwise, your thing also there are many missing links.
Those links, my lord, I may be allowed to bring on record, my lord. At the moment, I don't.
Just let us see. Let us see what reply comes from there. See, your very conduct approaching the court after 6 years, that is also is very, very questionable. And it is not that you are an uneducated person.
Your Lordship, as per my preliminary instructions also, the petitioner is not participating, Your Lordship.
It is not true, my lord.
This is why this page 30. See, there is a
Yes, Your
suspicion
Lordship.
that
This
yes.
was rescheduled at their request.
And there is a letter written by her also that we do not know what is the
Yes,
contents
Your
of that
Lordship.
and what she has paid for. Now, if she has basically asked for some more time and all, then we will not make any unnecessary intervention.
Yes, Your Lordship.
Exactly.
She cannot take one stand there and cannot take another stand.
Exactly, my lord. I have come with a clean hand, my
And,
lord. It's just that some of the missing link, my lord, I'll bring it on record, my lord.
No, that is okay. That is okay. Let them come with first their message. You just think
take
this, and
instructions,
especially
Your
the subsistence allowance. That is
Yes,
one
Your
thing you should take care of. So long a person is not dismissed and remains under suspension,
Your
that
Lordship.
becomes your duty.
Yes, Your Lordship. I'll take instructions on that, Your
And
Lordship.
we also do not know what takes so long for you to keep this departmental proceeding alive.
There must be
If
something,
somebody
Your
is not
Lordship,
cooperating, you should pass order accordingly.
Yes, Your
So it is
Lordship. I'll
not
take
that the
instructions.
petitioner only is at fault.
Yes,
My lord, my submission may be recorded, my lord. It is not that I did not participate, my lord. I was never
We are
communicated.
not saying anything about anything. We will just issue notice. Okay. Not Mr. Gurung, Learned Counsel, appearing for the petitioner. Issue notice returnable in 3 weeks.
Yes, Your Lordship. And for all the respondents, Your Lordship.
We'll have shorter time, 2 weeks. Let it be 2 weeks. 2 weeks. MS Judge Learned. GA, your GA
GA, Your Lordship.
appears for the respondent numbers 1, 2, and 3. Stop, hence no further notice is called for. Stop. The learned GA shall obtain necessary instruction in the matter before the next day. List after 3 weeks. Or list after 2 weeks.
Deeply obliged.
Authorised, Your Lordship.
Item number 3.
Yes.
Lordship, by last order, appropriate steps had to be taken to implement. Lordships,
Yes.
the steps have been taken.
Has it been taken?
Yes, Lordships. Lordships, I'm praying.
No, where
2
is that?
weeks,
Where is that? The petition has remained this thing unchanged. You have not added that person impleaded as.
Lordships, the impleaded as respondent number 6.
Yes, it is there. Yes. So,
Lordships, I'm praying for 2 weeks adjournment, Lordships.
yes.
No objection. In fact, my lord, the other respondents are yet to appear. Respondents.
Who are the respondents were to appear?
2 to 5. Sorry, my lord, 3 to 5.
But the notice has been 3 to 5. Yes.
My lord, sorry.
Your appearance has already been.
Yes, on the last
Only for
occasion.
respondent number 3.
Okay, just say. It is submitted.
So the remaining, my lord, is 2, 4, and 5.
It is submitted by the Learned Counsel for the petitioner that the step has been taken, necessary step has been taken to amend the cause list in pursuant to the order passed by this court. Stop. Now this matter will go for hearing or what?
For admission hearing, my lord, because here I am raising the issue maintaining.
Admission hearing.
But this is already there in this thing.
Yes, my lord.
Okay. Just say as per for the Learned Counsel for the petitioner. This is matter after. When do you want it, sir?
Lordships, 2 weeks.
This is solid for you.
2 weeks.
This is matter after 2 weeks.
Obliged.
Item number 2.
Yes.
Lordship, the last occasion the private respondent have submitted some, they have prepared some chart sheet. According to your calculation, there is a delay of 659, but
yes.
according to my calculation, it was 491. So they have given the copy of that chart sheet prepared by them also. See, Lordship, here there is a, of course, my calculation and their calculation, there is a difference. Well, Lordship, maybe there may be some defect in my calculation. That
If there is a
actually-
defect,
but
then that will go against you.
Yes, Lordship.
If there is a defect, then that will go against you.
But my submission is that is according to them. But according to me, That is their claim. But
And
according to
then-
me,
then-
I rely on
then,
that.
Then the court will take a call who is correct, who is not correct.
So I'm relying only on this para 24, page 9 of the petition, where I have elaborated actually the. I'm relying only on that para because there I've explained it then calculated. The JHDC and other respondent, they have no objection. They are not filing an objection also. They said they will not have any objection.
It's okay. This doesn't mean that they do not have no objection. They do not have any objection. The rear explanation has to be accepted. It doesn't say so.
No, no. I'm not.
Okay. District Council may not have any objection. Yes, there is a delay of how many total delay of how many days?
According to their chart, my lord, it's they are saying that it's 600.
No, not you are according to you say about
yes,
your
according,
thing.
according to me, there is only 400.
For you, just say,
Yes.
just let us take your calculation first. Then we'll look at their chart.
According to my petition, is 491 days delay.
491 days, according to you.
Yes.
Now, your matter was dismissed on 1st February
Well,
2021.
yes, 1st February 2021.
Isn't it? And the Supreme Court order with regard to the period to be excluded was available to you till 3rd January 2022, isn't it?
Lordship. This one, according to this one is.
Just a minute. Your matter was dismissed on 1st February 2021. The Supreme Court order was till
Actually.
it is covering
Understanding.
the period from 53 2023 till 22/10/2021. Isn't it?
I think it's a 14,
That is what the Supreme Court order.
14/03/2021.
What is the period which was excluded by the Supreme Court? This is 15/3/2022 to 28/2/2022. Is it?
Yes, Lordship. 22 September. Exclusive period, yes. 202.
So none of you know what is the period excluded.
The chart they have prepared 15.
Forget about their chart. Just tell us.
Yes. Actually,
your entitlement
yes, Lordship,
for exemption.
According to my understanding, Lordship,
Tell us according to the Supreme Court order what is the period.
the
to be
period is
excluded.
period will be on 15 March 2020 till 14 March 2021. The page 30 is there
Page 30
of my application. Para 2 and 3 also.
Just a minute. Yes, para?
Para 2 is there.
Yes.
Page 30.
Yes.
In case where the limitation would have expired during the period between 15/03/2020 till 14/03/2021, notwithstanding the actual balance period of limitation remaining, all persons are have the limitation period of 90 days from 15/03/2021.
Just a minute, say 1 second. That means the period of 15/3/2020 till to 14/3/2021 to be excluded,
Yes,
isn't it?
Lordship.
Then from 15/3 you have 90 days time.
Yes, Lordship.
Correct or not?
Yes, Lordship.
Now tell us for your case when your matter was dismissed.
Case dismissed on was dismissed
On 1/2/2021.
1/2/2021.
And you filed the application on 21/6/2024.
Yes, Lordship.
Huh? Is it correct?
Yes, Lordship.
So 1/2/2021, it means your case was dismissed on which date, you said?
01/02/2021.
Now, if your case dismissed on 01/02/2021,
Yes.
then your limitation would start from which date?
We will start from 28/02/2022. I mentioned in the para 3. I will start from 4/01/2022. Will start from 2.
There, your petition, there is no calculation, no computation, nothing is there. It's so confusing, nothing. There is no proper calculation in your petition. You've left everything up in the court to calculate. Now, if your petition was dismissed on 1/2/2021, then according to you, from which date your period of limitation would start?
It will start from 4/01/2022. Start.
That is according to you, isn't it? We are taking it as your submission. On what basis? From 4/1? Achha, from 90 days. Taking 90 days from
Taking 90 days from the dismissal.
Yes.
Of the
From 2/10, not from the disposal. 90 days from 2/10/2021. Yes. So you filed on which date?
Filed this petition
21st/6.
Just a minute.
around 18, no? Ah, 2106. This was filed on 2106.
Now you were supposed to file on 4/1/2022. You filed it on 21/6/2024.
Yes.
That means there was a delay of how many days? From 4/1/2022 till 21/6/2024.
It was a delay of 1,206.
How many days?
1,206.
Is it correct? 1,206.
Yes.
So there was a delay of 899 days, not 1026 days.
890. Yes, ma'am.
Isn't it?
Yes, ma'am.
Yes. Now, if there is a delay of 899 days, okay, starting from 4/1/2022, let us see which way explain delay of 899 days. Yes, just show us the how many days delay you have explained in your petition.
Yeah. Delay, actually, my explanation is the 491 days.
So, what will
Actual
happen
delay,
to,
excluding
where is that paragraph?
in para 23. Para 23 of my application.
Yes. So your the entire thing is a maximum of 491 days.
And then so para 24 sub para 3 also I have mentioned that.
Yes, but then these are breakup of all those. Okay, according to you also there was a delay of 889 days.
Yes. Yes, that part one I have said 898 days.
Yes, but then where is the explanation for all those days?
That's explanation, my lord. I put it in the para 14, then 18.
Where is the period mentioned?
Period mentioned is in by para 24 sub para 3.
Yes.
From the date of withdrawal of the application for restoration till the filing of the instant application for restoration as
What is withdrawal?
Because there,
where from withdrawal comes?
Earlier I have filed it, and again I withdraw that is the order also.
Okay, you filed this thing.
Yes.
Application of restoration, and that you withdraw it.
Withdraw it and again
Okay.
file it.
So anyway, you are not getting exemption for those period.
Yes. No.
Now, if your petition is filed of 21/6/2024, then what is your statement at subpara 1 and para 24? Para 24 subpara 1.
From dismissal of the petition till the filing of MCW, that MC.
Just read it. Go.
Okay,
then.
Lordship. From the dismissal of the writ petition 103 on 01/02/2021, and the restitution application was supposed to file within the period of 30 days. That is, the period of 30 days expired on 01/03/2021. But the applicant has filed the application on 18/08/2023 after the delay of 898 days.
That means it is that concern, that other.
That one.
So what we have to do here? This is already
No,
withdrawn.
thereafter I have the para 2 and 3 I have explained, my lord. That from the date of filing of MCW 181 of 2023 till the withdrawal of the 181 of 2023, there was a delay of 238 days. That is, the application for restoration was filed on 18/08/2023 and was withdrawn on 12/04/2024.
Yes. So
then next explanation, my lord, that 3, lordship, that from the date of withdrawal of the application for restoration till the filing of the instant application for restoration as on 21/06/2024, there was a delay of 70 days. That is to say, application for restoration was withdrawn on 12/04/2024, and the instant fresh application for restoration was filed on 21/06/2024. Therefore, the actual delay was 1,206, but excluding the period with effect from 15/03/2020 to 28/02/2022.
What? Why that 28/2/2022?
That was actually.
Where from that 28?
Actually, lordship, this was supposed to be 14/03/2021.
So it is in place of 14/03/2021. You have written.
Yes.
So?
It's supposed to be 2022. There is a one of a mistake in that 28.
So you, according to you, it is a clerical mistake.
Yes, lordship. Actually, it has to be 14/03/2021. 14/03/2021.
Yes.
So then which is equal to 715 days for the purpose of computing of limitation, and hence there is a delay of about 491 days from the dismissal of the writ petition 103 of 2017 till the filing of the instant application.
That means your calculation is wrong. That means your calculation is wrong, because you have made this calculation on the basis of 28/2/2022, not on 14/3/2021. So you have to redo your calculation. Because you have excluded the period from 15/3/2022 to 22/2022 instead of 14/3/2021. So that is almost a difference of 1 year.
1 year, 365 days.
364 days. 364 days. Yes. If you calculate it become 364 days. 364 days.
So that period is unexplained.
Your lordship, actually there is. I have calculated even calculating this is 491 days. So that means my calculation is bigger than, but if you calculate this, it's less than 491 days. You calculating.
Not understood. You see, your explanation is more puzzling. You see, it comes as a puzzle to the court.
No, lordship, my what I'm trying to say is, if you, my calculation is
your statement so far as para 3 is concerned, there was a delay. Actual delay is 1,206 days.
Yes.
And if you exclude that period from 15/2020 to 28/02/2022,
yes,
then it is equal to 715 days.
Yes, 715 days.
Hence, there is a delay of 490 days from dismissal of the writ petition also till the filing of the instant application. So you just explain us what is that.
Yes, sir. 419, it is 700.
It has become tougher than a mathematics class now.
It should have been 300.
You do not understand your own explanation. That is the problem. How to make the court understand?
Could be good. We have excluded this one. Excluding this one. Then 03.
And there is no explanation basically. It's a calculation given. And what for the delay, it is not there. It is not in, there is no explanation.
No, Lordship, this explanation actually have given in
See paragraph
the
22.
para 11.
Your para 20 is also on the basis of the so small this thing. There is also 28 2022. Where from you get that date, you do not know. Come to your paragraph 20.
Yes, yes, Lordship, it should have been the 14/03/2021.
Yes, so there is no exclusion of 715 days, that means. So from 715, if you deduct another 364 days or 65 days, then what remains? And who will explain that delay?
It should have been 14.
We have not been able to make head and tail out of your thing. At least this court with limited capacity of understanding, very difficult. Once you say the actual delay is 491 days, again you say it is 1206 days, again
Calculation.
just tell us, Mr. Sangma, one thing. Just give us in a simpler way. If you say, let us go by whatever you said in your petition. Now, according to you, after deducting the period which by the apex court order should be excluded, that there remains 491 days
Yes, Lordship.
of delay. It starts from which date?
This start from 14/03/2021.
14/03/2021.
2021. Yes.
Are you sure?
No.
Yes, it appears that you are also not sure.
It start my lord. It is 4/01/2022. 4/01/2022.
Where it is mentioned in your petition?
Lordship, that starting period should I did not mention.
Just tell us your explanation in which paragraph should be accepted by the court.
For explanation, Lordship,
Anyone from you who can have a better explanation for what has been stated in the petition.
My lord, there is, if we go in the literal meaning of the petition, there is no explanation given. It is the calculation which
That's
is
all right, but then you see, this court is struggling even to get the calculation as
even
far
the
as
calculation
terms.
is not correct, my lord. What-
Even if he says that if 491 days, that period starts from which date?
According to him, my lord, is 14/3/2021.
Where is that? Where
He
is
has not
mentioned?
stated. He has not stated exactly the date.
That is what the problem is. It is not stated anywhere in the petition. You have made a petition which you also do not understand, Mr. Sangma. Well, according to the calculation given by the private respondent number 1, who is appearing for 1?
Your Lordship, I'm for respondent number 1, Your Lordship.
Yes?
I'm for respondent number 1.
Okay, so according to your calculation, what is the delay? What is the period of delay?
Your Lordship, the conducting counsel is on legs, Your Lordship, so I don't have the instructions actually.
So why it took such a long time for you to say that?
You have given a chart according to them.
You should have said it.
My lord, according to them, my lord, the chart they have submitted is 659 days delay, total delay.
Which one? Oh. Yes. This one, huh? Okay. Just order, huh? This one. Oh, yes, sir. Oh, that's it. Oh, that's it. This is this one, huh? Yes, yes. Lordship. This one. Please, Lordship. This 28 actually this from where this is the order, Lordship. I think by mistake I have not because this there is in para 4 of that where it's start from 15/03/2020 till 28/02/2022.
What is the thing? Where
It is which I have mentioned actually. I think I have, by mistake there is an order, Lordship.
It shows. Then once you say that is not correct, now you say that is correct.
It is correct according to my petition. Yes.
It is not annexed with your petition.
I think by mistake why it's not there.
Give us a copy. Is it annexed with your petition or not?
No, I said, let me see. I think the 8. Oh, it is by 28. Oh, from here there is actually one. So it's missing there.
Okay, so the period of extension was, see, Mr. Day, you have seen that order.
Yes, my lord.
See, this has been extended.
Yes, my lord.
The earlier thing till 2021. So that means the chart given by, submitted by the private respondent of one hand is not correct. It has become a real puzzle, really.
But my lord, what I can humbly submit, even if my lord find there is a delay of 30 days, or maybe a 10 days delay, where is the explanation given by Melan?
That we understand, but then first we come to calculation. First we come to calculation at how many days delay has been explained.
Until unless this application, this case, is corrected, my lord, a proper calculation will not come. And even if proper calculation come, my lord, where is the explanation? My friend has to give the explanation. Why there is a delay of 10 days or 90 days or 200 days? That explanation is not there, my lord. And the court may not be in a position to, my lord, appreciate that application. He need to give the explanation, my lord, why there was a delay.
He has given explanation in his.
It is a calculation, my lord, in fact. It's not
Whether
an
it is
explanation.
acceptable to us or not, that we will see. We will just see. Let us see. Let us see what way. See. Since he is not saying that he has not given proper explanation. So if it is 90 days from 1/3/2022, the period would expire on which date, Mr. Sangma?
The yes, to calculate properly.
Now we have to make a fresh chart again after this order.
Lordship,
Yes.
I would like to pray for time.
You have to, your chart which you have given, submitted, that is not correct. You have not taken into consideration that the order which Mr. Sangma has placed just now. You have received a copy of the order. Have you received a copy of the order right now?
Your Lordship, we have it.
You show it to your senior.
Your Lordship.
Mr. Sangma, you also come with ready-made preparation. We'll have it next week. Your petition is a puzzle. It's a real puzzle. Just a one prayer made by the parties. This is matter after. I do not know what notes I have made.
Lordship,
Item number 3.
please, Lordship, can I have that order? I will just Xerox later.
You will Xerox later. You do not have extra copies.
No. Okay, Lordship, we'll get it. I'll have it. I have.
It's
give
up to you. You can take it and return it. It's no problem. Yes. Yes, Mr. Sheikh.
My lord, yes, counter is awaited by them.
Myself.
You can file up.
Oh, you have to file your affidavit in
Yes.
opposition. Okay. So how long? How much time?
3
you need?
weeks. Will be 3 weeks, Your Lordship.
Oh, sure.
You also will be filing.
Yes, Your Lordship. I have received instruction.
You have got instruction. You have received. So how much time you will need? Okay, just as pressed
3 weeks
for
now. Observe.
as pressed for on prayer made on behalf of the respondent number 1 to 4. Or just say on prayer made by MSS Bhattacharya, Learned GA, appearing for the respondent number 1 to 4, and Miss E.V. Pasa, Learned Counsel, appearing for the respondent number 5. 3 weeks time is granted
Much obliged.
for filing affidavit in opposition matter.
3. Hearing. Item number 19.
Lordship. 4 and 5. Different matter, but
Which one?
4 and 5.
Phone 5.
No, what is 4? Has it been same thing? And then what? There also you are asking for same prayer.
Yes, Your Lordship.
There you are for the writ petition 171 who is appearing.
I am there, Your Lordship. For respondent 1, 2, and 3, we are praying for some time, Your Lordship.
And same prayer by you.
3 weeks.
So just record the name of the council. Just say on prayer made by. Just change the name of the council. Okay. In item in WPC 171 is item number.
Item number 4.
Yes. Here you just say MS iLingua for
1, 2, and 3, Your
1,
Lordship.
2, 3. MS EV Pasa is for 4. You were not there. And then the other matter. Item next item. What is the next item?
That is also pension matter, item 5. Lordship.
What is the writ petition number?
That is 172.
172. Who is appearing for whom? 1 to 5. So we'll just say one prayer made by Mr. So-and-so. Learning Council appearing for 1 to 5 and MS Pasa. Learning Council appearing for 6. 3 time is granted for filing affidavit of opposition.
Must.
So just same order, only you have to change the name. You got it or not? See, these 3 matters. Only thing is that see, item number 3. Item number 3, you got it? There is no problem. Okay, that's all right. Yes.
Obliged, Lordship.
Must.
Hearing. Item 19.
Yes.
May it please your Lordship. Lordship, senior counsel is on legs before courtroom number 2, Lordship.
So what is to be done?
Lordship, I'll pray for 2 weeks' time.
What is this matter about, madam?
My lord, this is in an arbitration execution case. The court has allowed us. They had deposited the money. Department deposited the money in the execution proceedings. Then the court allowed us to withdraw the money on condition that for 50% of the amount we have to give bank guarantee, and for 50% indemnity bond. Initially, court has given that we have to give for 100%.
No, we have not understood. The deposit was made in an execution proceeding.
In execution
So
proceeding.
why there is a conditional release then? No.
Because there are 34 is pending. Section 34 challenging it is pending. But there is no stay. No stay in the 34. And just to strike a balance, first court said ki 100% on bank guarantee. Then we filed a petition because it's not possible to give bank guarantee. Giving bank guarantee means same amount of money we have to deposit in court and then bank will issue the bank guarantee. So court allowed us that okay, 50, after hearing both the parties, court allowed for 50% you give bank guarantee and for 50% on indemnity bond. Because the same court, commercial court, in a number of cases, has allowed to party to withdraw the money on indemnity bond itself. The previous presiding officer has allowed. Against that order, they have come by way of 227. But there is 227, whether your lordship will exercise jurisdiction under 227, because there is no jurisdictional error as such. It is not that the executing court without jurisdiction has passed the order.
I can understand that, but then apparently you see like this revision application under 2227 has been entertained by many high courts and all. So outrightly we cannot say it is not maintainable. Only is the thing that the grounds taken by
But
them.
in rarest of rare cases, court has accepted, provided there is jurisdictional error.
There is some.
There is apparent jurisdictional error
There is some
or
patent
yes,
illegality.
illegality.
So anyway, we'll.
This is the matter. You'll come after 2 weeks. No?
2 weeks, Lordship.
Yes, okay. We have need to know. We have Dr. Majid. Not objected to by senior counsel applying for the respondent number. You are applying for all the respondents.
No, he's
respondent number 2.
where for one.
How many respondents are there? Oh, there are 2 respondents. Okay, not objected by Ms. So-and-so and Mr. So-and-so. This is a matter for 2 weeks. Yes.
Much obliged. 21.
Item 21.